Good morning. We're back in action here. We've had a very busy morning, very informative morning, and looking forward to this next section. We're going to talk with our legislative counsel, Bradley Shulman. Been stepped up into the role nicely as far as in our other longtime counsel. And we're going to talk about municipal regulations of agriculture. Welcome. Come on up.
Thank you.
The floor is yours, sir.
Good morning, committee.
Morning.
My name is Bradley Shulman. It's a pleasure to meet you all in person.
Do you have you met everybody? We'll just go around. Just get
Sure. Yeah. Brian Collimore, I represent the Rutland District.
Great.
And we've met Rob Plunkett, Bennington.
Yep.
Steve Heffernan, Allison County District. Great.
Joe Major, Windsor.
Great.
Ben Russ Ingles, Orleans, Essex.
Right. Pleasure to meet all of you. Yeah, my name is Bradley Shulman, Office of Legislative Counsel, and I will be giving an overview of the Taft Street decision and the impact on municipal regulation. Just going to share my screen here. Just 1 second while I. Okay. And so this presentation will give an overview of the full name of the decision is In Re 8 Taft Street TRB and NOV appeals from the Vermont Supreme Court. We usually just refer to it as the Taft Street decision. This decision is dated May 30th. I think we caught wind of it in June, so we might refer to it as the June decision. I might refer to it as May 30th because that's what the Supreme Court says on its paperwork. But just for that piece of clarification, we're talking about the same thing. Okay, so before we begin, this is the relevant statute that the court was interpreting. The language is in bold here. So the statute prohibits a municipality in the regional planning and municipal and regional planning and development. Municipalities cannot regulate required agricultural practices. And traditionally, we thought that this meant that municipalities could not regulate agricultural activity that is subject to the required agricultural practices. And we'll see that the court read the statute more narrowly, and I'll explain that in just a moment. But some facts that kind of brought us to this moment where we're taking another look at that statute. The facts here, the case itself concerned a Duncan cannabis farm in the city of Essex Junction. The city's land development code prohibited agricultural activity in residential areas. This farm was located in a residential area, so the town issued several notices of violation of the city's ordinances. The farmer appealed, and the environmental division ruled in the farmer's favor. That court determined that the duck raising and cannabis operations were subject to required agricultural practices. So the city could not regulate that activity. And the farmer did not appeal to the Supreme Court. Sorry about that. The city and neighbors appealed to the Supreme Court and brought us to where we are here. And so the court ultimately took a much broader view. Again, prior to Taft Street, it was generally accepted that municipalities could not regulate agricultural activities subject to the RAPS rule. And the RAPS rule section 3.1 defines what kind of farming activity makes a farmer subject to the RAPS rule. So if you meet that criteria in the RAPS rule, it was generally understood that municipalities could not regulate the activity more broadly. So the court read the statute more narrowly. So instead of deciding that municipalities can't regulate agricultural practices, activities subject to the RAPS rule, the court held that municipalities are only restricted from regulating what the required agricultural practices are. So the court reasoned there's a difference between agricultural practices subject to the RAPS rule and agricultural practices required by the rule. Had the legislature intended to prohibit all municipal regulation of farming subject to the RAPS rule, it would have done so. However, it did not do so, and we presume it chose those words advisedly. The holding here is accordingly, the relevant statute does not prohibit all municipal regulation of farming if that farming is subject to the RAPS rule. And the landowner's duck raising operation not exempt from municipal zoning solely because his activities are subject to the RAPS rule. Rather, the statute prohibits municipal regulation required agricultural practices, or the agricultural land management standards intended to protect Vermont's waters established by the RAPS rule and impose on certain agricultural practices. So essentially, it's not the prohibition by statute does not prohibit regulation of agricultural activity. It just prohibits municipalities from regulating what those required agricultural practices are. So the secretary gets to make the RAPS rule, and the Secretary of Agriculture gets to make the RAPS rule, and municipalities cannot regulate how farmers are supposed to implement those rules. The municipalities can't regulate those rules itself. That's the narrow, that's how the court narrowed our understanding of municipal regulation here. So what that means then, because municipalities are now only restricted to regulating what's in the RAPS rule itself, the zone or the scope of what agricultural activity could be subject to regulation is not quite broad. So municipalities could regulate agricultural activity in terms of noise, traffic, road requirements, setback requirements, smell, hours of operation, parking, land use, and municipal regulation. There's broad authority for municipalities to now regulate agricultural activity, when before we thought that they were prohibited from doing that. Municipalities are restricted from regulating just the specific practices required by the RAPS rule. And the RAPS rule largely concerns water, drainage, manure, buffer zones, animal mortality management requirements, and things of that sort. Municipalities can't regulate those specific activities, can't regulate how a farmer is supposed to manage water, drainage, manure, and these things. Municipalities can't regulate those things. They can regulate a lot of other things that could be related to farming. Other exemptions by statute are still in place. And so there are still protections from nuisance lawsuits. There are still Act 250 exemptions that are still in place. This court case did not affect those exemptions. It just narrowed our understanding of that kind of broader exemption that we thought that municipalities had on regulating agricultural activity.
So scenarios dangerous. They're just dangerous stuff. I'm just going to try to paint it in a broader picture that would make more sense to us. You get a housing development. Next to that's 100-acre field. The municipality could say you're not going to spread manure between the hours of such and such time. You're not going to go past 7 o'clock at night. You're not going to start any earlier than 5 o'clock. If the wind's blowing in a certain direction, and so I mean they could really just make any rule that they wanted to, that they thought, and it's in their own fairness, they thought that was protecting this development from undue presence of agriculture. But they could make those types of rules.
Yes, and the authority to make those types of rules is broad. And they could regulate noise and hours of operation too. Things that neighbors might find to be annoying themselves. They could lobby their municipal governments to pass an ordinance, to pass a law that would restrict that activity. And they're currently now under this Taft Street decision. There's nothing necessarily stopping municipalities from doing that.
And it's not who was there first, any type of protection.
Not necessarily. And so farmers could attempt to litigate these things and exercise their rights under the law as any party would exercise their right under the law. Like if you had, like a fence in your backyard or something, and your neighbor wants you to remove the fence because they think it's an eyesore or something, and you might assert, okay, well, I've had this fence for a very long time, and I've been doing this for a very long way. Applying that to me, I should be grandfathered or granted an exemption or something of the sort. But that would require individualized litigation and individualized appeals and requests for variances, things of that sort.
As well as legal costs.
As well as legal costs, yes.
Thank you, Mr. Chair. So it would appear that this is a definitional issue to me, in that the General Assembly didn't do enough of a job in defining what farming is. Somehow it got tied to the RAPs, leaving out enough area in a sort of gray zone, I guess. That's how I take the Supreme Court decision to mean. They looked at it and said, I don't think they actually said this probably, but the end result might be the General Assembly needs to go back and take another look at the way in which they define farming and expand it if they in fact intend to protect farming.
I think that's right. And I pulled the statute back up again. And the text might be a little small here, but I pulled the statute back up again. And the statute itself says a bylaw shall not regulate required agricultural practices. And they read that by the plain language that you can't regulate the required agricultural practices. Up until this point, we were thinking, or the state thought that meant activities subject to the required agricultural practices. So your 15 goats, your cannabis farm, your duck raising operation, all subject to the required agricultural practices. That's not necessarily the case. Just the bold language is what the court is looking at there. And you are correct that the court did use language that said if the legislature wanted to broaden the exemption, that it could have chosen language to do that.
And still can.
And still can. And I think that may or may, I think that was the practice up until this point. But the court wasn't looking at practices, wasn't looking at history, wasn't looking at testimony about how these rules have been working. It just looked at the plain language, and it just looked at the words on the statute, and it kind of ignored the broader scope of how we did things. And that is in line with statutory interpretation, or some statutory interpretations that you'll get from judges. Is I'm just looking at the statute and I'm going to ignore everything else.
But they typically will make interpretations based on precedent. And they just didn't on this time.
Let me I can answer it this way. I'm not familiar with another Supreme Court case in which they have interpreted the statute more broadly. So in that sense, I don't think that they're not looking at their precedent. What they're not looking at is the precedent set by how the state has managed
200 years of activity.
Exactly. And I think I was chatting about this with Mike, but I think, our understanding of this rule, the drafting goes back 25, 30 years of this drafting in particular. We don't have a specific date, but it's been a long time and a long understanding of how we've done this. And so the court didn't look at that history or precedent, so to speak. But in terms of its own precedent, I'm not familiar with another case that they have addressed this particular statute in this way.
So why haven't we had conversations, council, from Agency of Agriculture or even from this committee? I mean, I think you've shed some light onto all language. Why hasn't there been so far any conversations about changing the language?
I think that is those conversations are coming. And I don't want to speak for the Agency of Agriculture on their behalf, but I do anticipate that they will propose a sort of legislative fix for this committee to consider.
Okay. Yes.
Thank you, Mr. Chair. Bradley, are you familiar with any other cases apart from this farming piece where a Supreme Court decision was reached. And in the immediate session following that decision, legislation was introduced, which further clarified, if you want to take one way of looking at it, or countermanded what the Supreme Court did in their decision.
That is a good question. Not in the agriculture context. I do know in the housing context many years ago, if that's helpful for you.
Sure.
But in the housing context, the Supreme Court ruled that if you're trying to terminate someone's tenancy, a landlord trying to terminate a tenancy, and the landlord gives a notice to vacate, saying I want to end your tenancy in 30 days, and then they give a subsequent notice to vacate, saying, okay, I want you to terminate your tenancy in another 30 days. The Supreme Court ruled that the subsequent notice to terminate tenancy voids the first one. And that might make sense, but in the statutory context, in that statutory world, that may not have been the intent of the legislature, and it certainly wasn't the intent of landlords. And so the legislature did pass a law, either the subsequent session or maybe 2 sessions later. It was very close in time to this decision, saying a subsequent notice to terminate tenancy does not void the first one. And so that there's precedent for the legislature to take action from a Supreme Court case that has interpreted laws in ways that perhaps are new or unexpected. I'm not familiar in the agriculture context, though.
Okay. Good answer. Thank you.
I said earlier today that there's rumors or there's gossip, but then there's things that just seem to swirl around. And I'm not in the habit of criticizing any court, especially the Supreme Court. But it seems to be floating back through that it seems that maybe they got this one wrong. Maybe that they should have put more context with their decision. I don't know that to be true, but I do think that now we're very helpful meeting with you today, that there is fix to it. I feel that, and it's not, and I don't think it's going to be something that it's going to be a legal battle to do. It seems like it's just, okay, well, yeah, no, fix your language and we'll be fine.
And I think that's the right way to go about it. I think for better or for worse, this decision is one that the legislature and the agency and farmers are stuck with, and trying to take action to clarify and change the statute to comport with a different interpretation, I think is wise.
Senator Plunkett?
Yeah, are you, I guess, so let's imagine we're trying to replace this with, instead of required agricultural practices, it's farming or some phrase as defined in some citation in statute. Do you know where that citation in statute might be of what was understood prior to this decision? What would be? Is it just farming as defined in Title 12 or wherever?
I don't have the citation off the top of my head, but yes, the answer to your question is yes.
So there's some definition
Yes.
in there somewhere.
Yes, and I think that there is language floating around.
Yeah, we haven't seen that language.
Right. That might get to that point, but then that is good thinking, and that is coming.
That's
Ready?
Is that something we will be able to put in the miscellaneous though?
Yes. Yes. Yeah, we'll be having some conversations about that. We can be sure. So we have the agency coming in, and we'll work with Council Showman, this the agency, and Collier, and we will tackle this for sure. Anything else?
No, great job.
Great job. Thank you.
Thank you.
You were very, very impactful, and we appreciate you. Very nice to meet you, and we look forward to having a great working relationship with you.
I appreciate that. Feelings mutual, and it's a pleasure to meet all of you.
Thank you.
Thank you.
Come here.
Take care.
Committee, anything else? Any conversations about today?
Not today, but I don't know if you've been aware, but, House passed a 60.
H, or is it?
Yeah.
Yeah, so the only thing, which we're gonna have to discuss is a included portion.
Yeah.
And it's in. And so.
Thank you, council.
I don't know. And we're gonna have to decide whether we want to go as is or go to conference.
So let me ask you, Senator Major, didn't it get passed and then sent to the House Appropriations Committee? Because I don't know if there's any money in the bill.
There is none.
There is,
Okay.
right,
So I think to your, Senator Major, I think we have to have a conversation because the sponsor of the bill is in, Senate Natural Resources. And then where they handle forestry. So they might not be too keen to
yeah,
I'm with you.
Yeah,
but
I agree.
I think that we need to have a conversation with them to whether they wanna, we're gonna be stepping on some pretty big toes if we go down that route, but I hear you.
And, then
And maybe we
Yeah.
ought to, before you go, and I apologize.
No.
And maybe we ought to have a conversation with the sponsor of the bill,
yes,
if that was her,
Within-
if that was her intent.
and she's in that
Right,
committee as
right.
well, so, the other part of it is, I mean, I think we were asking for $1 million, if I'm not.
Well, we were after 7 million.
I know.
That's Sanders, so yeah,
There's
seven,
this.
right,
It ended up like this.
yeah,
Um,
or this.
But I mean, just to have something, even if it's just almost a placeholder to get it through. But
So let me throw something else out there. Sure. With that. Why couldn't we partner with these folks? In some way? And, because they seem to have the monies. And I'm just, it's a lot, it's a throw out into left field. But I'm wondering if there's any ways that we could craft S60 to, I don't know, they seem to have plenty of money.
Hmm.
And maybe again, with the offline discussion that we had about the trust of, who you do business with and not, and maybe that would be the way. So it's not anything that we make a decision on today, but it would be nice to get in that bill, some real dollars.
and I think, I'm sorry,
Well, the only thing I was thinking, these are loans
yeah.
for the most part.
Okay,
S60 were
More
No.
grant.
more like grants.
good point.
Um,
Good point. I missed that. I did.
well, no, I didn't miss it. I just,
But I mean,
it's tons of money.
but to your point, maybe they have some kind of grant program separate to this.
Yes.
Yes,
Yeah.
that we could,
Yeah, you call me.
Sure,
Okay,
she might be able to say, we can't, but
yes.
Right.
Yes,
X,
Right.
Y, and Z would be
Yeah.
able to do something.
because
will you talk to Senator Hardy?
because what I've heard is just, the drought just,
Oh, yeah.
the testimony just killed. I mean, in my district. And it's not, and sometimes that was the one thing, sometimes we just think of crop loss, but it was, cattle farms, because you had to bring in the feed and dairy farmers as well. And
Yep.
just, it was just all around, and it was just, so hurtful.
Yeah,
Towards
we have dairy farmers that are in general bringing in feed as far as Minnesota.
Yeah. And then having to, truck in water as well is, what I was hearing. But you know what? The farmers are resilient, going to the fairs across on to Addison. They're resilient. They'll have a smile on their face and willing to get through and want to try to support them as much as we can.
Sarah Plunkett, you know where we need to be on language, as far as for this fix that we're doing, you're comfortable with that?
Well, yes, I think there's gonna be more of a discussion. My druthers would be to just return everything to where it was before the decision. Rather than trying to finagle something. But that's, so
How do you
but
think that's?
the LGT's proposal makes some sense. I don't know a lot of the details on whether any of those places could potentially be even viable for farming. So that might be just a point on tier 1A being still being regulated. So I think there's still some questions on that, but I want to see the language proposed by the agency.
I think you'll find there's more than one definition of farming.
Oh, there are many definitions. It's, which one do we point to be the one that was understood prior to that decision? And so, but there's still some questions, but I think we'll get there. It won't be that difficult, like you said.
Do you think so? Yeah, I mean,
I think so.
okay. So
The House started to look at this too.
I don't know. We're the Senate.
All right.
Oh, you know what? No, because they're speaking to him tomorrow, they said.
Yeah.
They're speaking
But,
to us.
we'll get it, nothing on Senator Plunkett.
Yeah, I want to say I don't. Yeah, I shouldn't say anything at all because I talked to Dave Durfee and I think we had mentioned this, but I don't.
Well, great morning. Good job as always. Very proud of this committee. I'm sorry to say that over and over and over, but I am.
Oh, we never tired of hearing. And I think you will did a great job with the witnesses.
No, I think we had.
As Joe knows, it's good practice for me.
No, we had a great day. We had, and Linda, yeah, you did a fantastic job of setting up our agenda today. We flowed right straight through. It was a really, really good day. So, yeah, so we have a lot of stuff. So I think that you're seeing a lot on how this session's gonna lay out, from the start of the discussion that we had on the first day about touching a lot of things. We're just gonna touch them. We're gonna grab them as they come by us.
Yeah.
It's sometimes you can lay out the greatest plans in the whole wide world that you want, but if you don't have the information as far as how you're gonna get there, you have to hear that first. And I think this last section was, I think the whole day was good. So thank you guys for your hard work and